Thank you, Roderick. I'm not absolutely sure that had I known what was going to happen, I would have necessarily chosen this date to lecture on this particular subject, setting myself the task as I have of trying to hit a moving target. If you study the news media and teach would-be journalists as I do, the last couple of years have been remarkable ones. We learnt more about the operations of certain newspapers than probably we wanted to know, and we certainly learnt more than we had learnt in the previous 20 years about the printed news media in general. There was a very enjoyable irony about this, and one well worth relishing. Newspapers, and I speak, as you've heard, as an ex-newspaper journalist, are very keen on inspecting any other activity whose working they might fancy revealing to their readers. Journalists, however, are hypocrites and not keen at all on being inspected themselves. Proprietors have not been in the habit of explaining themselves to anyone. But the phone hacking scandal did make that happen. A spell which had protected those proprietors like Rupert Murdoch from closer inspection and accountability was broken. And how exactly the spell had been woven in the first place was one of the themes of the Leveson Inquiry. So you can say, to change the metaphor, a lid was lifted. But now, and another irony I think, it's been shut down again. It's a bit hard to know what's going on because the arguments set off by the publication of the Leveson report at the end of November have now moved on to parliamentary wrangling behind closed doors, and we only know what we know from selective and self-serving leaks. Experts are arguing over what my ex-colleague Matthew Paris rather nicely called each sliver of whalebone in the disputed legal corsetry of statutory underpinning. So a spectacular public humiliation has become a complex technical wrangle. The aggregate disclosure that Levison brought about sharpened and shifted public consciousness. No one could any longer deny or minimize the simple fact that something had gone very horribly wrong. But I am going to argue this evening that we may be at some risk of overcompensating. Much of the public argument, shaped by celebrity victims and the shrewdly steered group hacked off, turns on whether the government will implement Levison in full or fail to do so. I think this is the wrong end of the telescope to be looking down. The danger is, or there is an equal danger, that political parties will lurch into changes which they will come to regret. More of that in a moment. I'd like to sort, if I can, all this into some sort of perspective and do it by trying to answer three questions. Why did this crisis occur? What does it tell us? And what should be done now? My first question, why did this occur? And particularly, why did it happen when it did? You may say, well, it was all about phone hacking, wasn't it? Yes, indeed it was. But to see why, I think we need to wind history back a few years. Not least because Lord Leveson himself saw his inquiry in a very long historical perspective. He said, and I quote, that his inquiry was established to address arguably the greatest crisis in public confidence in information privacy since the creation of the data privacy regime. And he was, we must assume, referring to the Data Protection Act of 1998, 15 years ago. And actually, he saw his inquiry also as an opportunity to turn around a record of failure which stretched back 60 years. 3 royal commissions on the press, 2 other inquiries specifically into privacy since the Second World War, and Leveson wrote they had left problems, and I quote, broadly unchanged and unaddressed. Now, not everybody saw it that way. You could hear, while it was going on, 3 objections about the Leveson inquiry. 1, that it was grossly overblown reaction to simple law-breaking, that we'd somehow heard it all before, and third and last, that even to open up the question of regulation of the press is threatening, or chilling in lawyers' jargon, to press freedom. There's a bit of truth in the first claim, that it was a very, very wide inquiry, and I think the report does show that in the time he was given, Leveson felt that he couldn't really do justice to all of the items on the very long shopping list in his terms of reference. Even at The Guardian, whose disclosures uncovered the phone hacking scandal, they were a little surprised at the breadth of the inquiry's scope. They thought that what they were doing was exposing stuff which would be corrected by the enforcement of the law, and actually it went a great deal wider. But there is no truth at all in the idea that we, whoever that might be, had heard it all before. Some journalists may have known something, but many didn't, and certainly the public didn't. Still less is it true that even discussing these issues somehow creates a climate of fear which prevents important truth being known. Before he ever recommended anything, Levison performed an immensely valuable service by simply ventilating and recording a large amount of information which deserved to be known. The interpretation of that information has generated a lot of megaphone politics. An organization called the Free Speech Network, strongly opposed to any form of new legislation on the media, produced an advertisement just before the Leveson report was published. The advertisement objected to any possibility that the press might be shackled by a new law and showed a picture of 6 front pages, asking if these pages would have been published under state regulation, as they called it. The advertisement was careful not to try and answer its own question. The stories were Daily Telegraph on MP's expenses, a Guardian front page on phone hacking, the Daily Mail accusing 6 men of being involved in the killing of Stephen Lawrence, the Sun, more recently, on Andrew Mitchell MP, allegedly calling policemen plebs, a Times investigation on rich tax avoiders, and the Mirror on Jen Prescott's affair with his secretary when he was government minister. You could, at a stretch, just about argue that the last of those, the story about Prescott, could have got a newspaper into trouble after, I hope not before, it had been published. But I doubt even that. It is fraudulent to suggest that any of the other stories would have been in trouble if every Leveson recommendation had been followed to the letter. If those stories raise any issues, they are ones of law and not of regulation. What we now call journalism has always existed in a structure of law. Libel, contempt of court, privacy, harassment, data protection, copyright, interception of communications of various kinds. Not even that list is exhaustive, but you get the point. Freedom of the press has been expanded over centuries, but it has always been a balance between rights and obligations hammered out in particular social and political conditions and embedded or entrenched by constitutive decisions made by governments. In Britain, we've ended up with a mixed system of rules for news media. Strict regulation written into law for broadcast, relatively light self-regulation so far for print, and virtually no regulation at all for the internet. Leveson thought that a mixed system was better. His concentration on press regulation was designed to preserve a mixed system. He did not think that multi-platform news, under which the frontiers between different platforms on which you can transmit news, suggested that regulation should converge. I'm sorry to say that he didn't really consider that question and dodged around it. The heart of Leveson is privacy versus free expression. And it is important to remember that that is a clash of rights. You can't solve a clash of rights. You can't settle it definitively. You can only manage it, and the search is for the best balance. So in the background to Leveson, there were 2 important decisions in the recent past which are part of the story. There was the Data Protection Act in 1998, looking at controlling how information could be got out of databases. There were no prison penalties for journalists, and there was a public interest defense, and the Act set up the office of something called the Information Commissioner. Before that, strictly on the privacy track, there had been an inquiry in 1990 by a distinguished lawyer called Sir David Calcutt. He was very scathing. This is back in 1990, don't forget. He was very scathing about the self-regulation system for the press, said it wasn't in order, gave them a short number of years to improve things. He held a second brief revisiting inquiry in 1992, reported in 1993, and said there should be a privacy law. This just isn't good enough. You're going to have to do much better. One way and another, by combination of the fact that this was the John Major government in the midst of European crises and a good many others, and the fact that there was very powerful lobbying by the press groups, Calcutt's proposals were derailed. They were brought back in some form in the Human Rights Act, which incorporated the European Convention of Human Rights into British law in 1998. But that created a privacy law by simply saying there is a right to the freedom of expression, there is a right to privacy. It made those two flat statements and then left the judges and the courts to sort out everything after that. It didn't work perfectly. Please note that both of these laws, the Data Protection Act and the Human Rights Act, have public interest tests of sorts built into them. Public interest tests come in various forms. They're essentially grounds on which an apparent breach of the law may be justified. They're a way of testing ends against means. Now, at the time that all these debates and arguments and lobbying were going on in Britain, we were not the only country to be talking about this kind of thing. Australian judges were developing a tort of unjustified invasion of privacy in the 90s as well. The European Court of Human Rights ruled in 2004 that a long lens picture of Princess Caroline of Monaco when she was on a public beach was not okay and violated her privacy. The court ruled, eccentrically I think, that her right to privacy had been breached because such pictures did not contribute to public debate over the role of the princess. Just try imagining the application of that kind of law here. Tony Blair, describing the media as feral beasts worried about the effect of 24/7 accelerated news on public life, and the paparazzi pursuit of Princess Diana left a very powerful image imprinted on the public imagination. One last piece of historical background. In 2001, before anybody had thought about phone hacking in connection with journalism, two academics, David Morrison and Michael Svenevig, did some opinion research on attitudes to the public interest, the media, and privacy. Media professionals, they discovered, didn't want legal intervention in deciding the public interest. No great surprise there. The opinion of the public that they polled and talked to in focus groups, however, was quite different. As the authors put it, the majority of the public approve of quite firm parameters being set on what the media can do in the name of serving the public interest. So well before these issues were highlighted by phone hacking and associated alleged crimes, people seemed to have been clear that unlimited invasion of privacy wasn't such a good idea, and that public interest was one way of saying where it should stop. What the public had had the common sense to realise was something which a number of editors can't really bring themselves to admit yet. Ideas about press freedom were mostly formulated in an age in which the only media were printed media, and they circulated inside an educated elite. The arrival of mass media, visual media, and finally the internet have altered the equation. Power and influence are greater, they can be concentrated in a smaller number of hands. The contrast between truth and falsehood, envisaged by John Stuart Mill, does not invariably result in the victory of the truth. Scholars such as Honora O'Neill in Britain or James Carey in America were pointing out, or more or less simultaneously and long before phone hacking, that big TV networks and press barons weren't the powers that they are in the modern age when the First Amendment to the American Constitution was passed or J.S. Mill was writing about press freedom. So these developments, new laws, inquiries, and a growing sense that there was something wrong, intersected with a quite different crisis affecting printed news. The business model for daily printed newspapers is in very deep, long-term trouble. I say daily printed newspapers because weekend papers and magazines are a bit better off. Please note that I am not about to argue that financial trouble for newspaper excuses anything at all, but it is relevant to what happened at Levison and probably what happens afterwards. Here are a few quick dimensions of what this difficulty is. The peak year for the total circulations of British national newspapers was 1950. Their aggregate circulations have been coming down, there have been bumps and ups and downs, but they've been coming down ever since that. The dirty secret of national newspapers, or the other dirty secret if you prefer, is how elderly their readers are. They don't declare these statistics, but from a certain amount of inside knowledge, I think I can guess that none of them will have average reader ages of under 45, and several of them over 50. And those are the averages, don't forget. These crises did not start with the internet just made them worse. Popular national papers in Britain and in most other places have been going downwards in circulation for 2 decades, and that goes back well before the internet. This has accelerated very sharply since about 2008, 2009. Obviously, there's a little bit of recession effect going on in there, but between 2005 and 2010, the number of households in Britain that had broadband doubled. It doubled from about 1/3 to 2/3 just in 5 years. It's a very, very fast speed up. And at that point, the fall in newspaper circulations began to accelerate. And even in the countries that seemed relatively immune to this kind of thing, in Europe, Germany and Finland, the growth zones of China and India, even in those countries, the growth of newspapers has now begun to stall, even in India and China. Last aspect of the crisis, no income from the internet is offsetting the falls in print advertising revenue. The point at which this intersected with Levison was very well caught in an exchange between Levison and Adam Bolton, the political editor of Sky News. Bolton had been talking to Levison about the competitive pressures which are threatening the viability of print media, and because of electronic routes for distributing information, and I quote Bolton, print media had been forced to a certain extent into a secondary market of comment and disclosure. And Levison says that's presumably got worse, not merely because of the internet, the elephant in the room, but also as, for example, government departments put more material out electronically themselves. Indeed, says Bolton, and Levison goes on, it's all very well handing out a press release to the journalists in the room, but if they can press a button and send it to every journalist in the country, then you need something different. I'd not really thought about it. Bolton says, the point is they don't even send it to every journalist in the country, they send it to every member of the public. So if you like, the traditional way that a lot of people started out in the print media, sort of rewriting press releases and making a phone call, you can't do that anymore because it's already out there. Levison. So it's critical that the press look for some other way of adding value to the story. Bolton. Exactly, yes. And that, I think in some areas, perhaps pertinent to this inquiry, that's led to a degree of desperation in the pursuit of something different. That's very interesting, said Lord Levison. So we have 3 forces tending towards a car crash. Economic desperation, richer opportunities for the interception and leakage of electronic information, and I think we could add something of a sense of immunity from danger in News International, which at that time owned and ran 4 major papers. Actually, under the surface, there was a very high degree of dependence on law-breaking already, well across quite a lot of newspapers. This was revealed in an operation that has become known, as is in the Levison report, as Operation Motorman. It was actually the accidental discovery of the archives of a private detective who worked in Hampshire. When they looked at his work between 1997 and 2003, they discovered that he had done 13,000 transactions worth somewhere between £300,000 and £500,000 for journalists. Basically, blagging, addresses, ex-directory numbers, that kind of thing. In that period, 91 reporters from the Daily Mail and the Mail on Sunday had commissioned 1,218 pieces of information from him. The prosecution fizzled out. There was no prosecution of journalists, despite the fact that the Information Commissioner was plainly told that almost all of them had no public interest defence. The Press Complaints Commission said very little and did absolutely nothing. For quite understandable and very good reasons, this episode is analysed in some detail in Levison's report, and he concludes at the end that if that had gone differently, it might just possibly have been a turning point and might have prevented phone hacking and associated crimes being as bad as they were. Now, the story of the actual trigger for the Leveson Inquiry is probably pretty well known. In 2006, 2 people were arrested, one of them a News of the World reporter, one of them a private detective. They were convicted. They were described by their employers as rogue apples. Clive Goodman, the News of the World reporter, actually assumed that he could go back to work at the News of the World after he had been in prison, which, as Levison remarks in an acid aside, tells you something about the assumptions of that period. The police then managed either to forget all the additional evidence about phone hacking or they messed it up. It's really honestly not clear from the Levison report which. The denials of wider responsibility at News International continued until 2011, and many opportunities for delving into the truth of what had happened were missed. In July 2011, it was revealed that the phone hack victims of Glenn Mulcair, the detective, had included Millie Dowler, the murdered schoolgirl. And then what had seemed like a story in which people rationed their sympathy because it was a bit about celebrities and so on, really became a major item. And it was a disaster for News International and its owner, News Corporation. Let's not forget they had to shut a newspaper and, worse, withdraw the bid for the 61% of Sky Television for which they were bidding at the time. And it had blowback not just on newspapers. The Prime Minister, I would guess, probably regrets setting up the Leveson Inquiry with terms of reference quite as wide. You will remember, no doubt, Rebecca Brooks and the LOL texts. So the police restarted their investigations and discovered that phone hacking had been the least of it. Don't forget that when the criminal trials start in September, phone hacking is almost the least serious offence which they will be trying. Conspiracy to pervert the course of justice and bribery of public servants are treated vastly more seriously by the courts. 144 of the civil cases were settled last week only. So this has been a two-part public humiliation for several newspapers, and we've only had part one. The trials will be part two. Theoretically, there is a possible second phase of the Leveson Inquiry. The first phase, which we've already had, was the thematic one, supposed to recommend policy answers, and he can, if the government and he so decide, hold a second phase after the criminal trials. I, like a lot of other people, think that's rather unlikely, but it could be a three-phase humiliation, just possibly. What does it tell us? I'm going to divide this answer into two bits. What Levison actually says, not particularly well reported, and secondly, what I think, and come to that, what I told Levison. Levison did a very important thing by abandoning the style of distilled, impersonal English in which many of these reports are written. He wrote at length. I would like to be able to point you to a Levison report, but it weighs 10 kilograms, and I couldn't be bothered to get the wheelie suitcase down to bring it here. It's enormously long, and he goes into a lot of detail. So he has created a historical record of some importance. On a single page, he reporting which can only be described as appallingly cruel, contributing to 4 suicides. He is very, very scathing about self-regulation. I will just make one story here stand for a number. The Press Complaints Commission was chaired in the 1990s by an affable conservative peer, many people in this room will remember, from news bulletins and so on, called Lord Wakeham. After some particular scandal, I think it may have been the recommendations from Calcutt that I spoke about a moment ago, Wakeham said that he was going to stiffen up the system by making employers responsible, by having the Press Complaints Code of Conduct written into journalists' employment contracts so that their good behaviour could be enforced by their employers. It's a perfectly good idea in principle, but it depends entirely on the attitude of employers to what has been happening. And there is a very funny passage in the Leveson report in which Leveson looks at an episode which you can see from more than one angle. The News of the World had taken some long lens photographs of, I think it was Countess Spencer when she was receiving treatment in a drug clinic. Anyway, there was an enormous fuss, and the News of the World was censured by the Press Complaints Commission. And this was the sort of thing which Lord Wakeham had said would be supposed to happen, would improve standards and so on and so forth. We have, of course, among other things, Piers Morgan's diaries. Now, they may not be wholly accurate, and they were written a long time after the events they purport to record, but nevertheless, he records a conversation with Rupert Murdoch in which Rupert in which Rupert Murdoch says to him, "I'm awfully sorry about that press complaints thingamajig." When he gave evidence to Levison, Morgan said Rupert Murdoch didn't give a toss, his phrase, about regulation of any kind. Murdoch, in his turn, said he did not remember using language like that. There are many episodes of this kind in the report. And the other amusing bit, if you're a connoisseur of lethally polite dismissal language, have a look at the section of the Leveson report in which he dumps on a proposal by two more Conservative peers, Lords Hunt and Lord Black, who attempted to revamp and rebrand the Press Complaints Commission in time to have Leveson approve their idea. Leveson did not think much of their suggestions and is very brisk in saying so. He is very clear, Leveson, that he thinks the idea of press freedom, the claim of press freedom, has been contaminated by a lot of what has happened. He himself asked a question right at the beginning of the inquiry. He said, "Who guards the guardians?" And in what I think is probably the single soundbite he would like the report to be remembered for, he says, he repeats this question and says, "The answer to the question of who guards the guardians cannot be no one." So he proposes the bit that became controversial. He proposes a regulator with much tougher powers, and I'll go into those in 1 second, but he says there's got to be some form of quality control for this. We've got to check that it's working properly. And if we don't embed that in statute, it's not likely to work. It'll get pushed over, diluted, thrust aside, or whatever it is. And the proposals for the specific working of the regulator, right of reply, much greater transparency, strong funding, full measures for independence, most of those are now, in the light of the shift of attitudes, relatively uncontroversial. And I think whatever happens as a result of Leveson, the inquiry and investigation into things that have gone wrong in newspapers and stimulated by third-party complaints, something that was impossible under the old PCC system, is very likely to happen. Leveson said a lot of not particularly impressive things about journalists recording their exchanges with police and politicians. I think that's probably going to be the most rapidly forgotten bit of his report. But he was just really focused on how to control the power of some popular papers. He said very little about plurality of ownership. He just wanted it better measured. And I think it has to be said that he really just dodged around that issue. I come at all of the core issues of Leveson from a slightly different perspective. I sympathise with his anger about the abuse, but I don't really believe that any free, open and plural society will have a nicely behaved news media. And I think Leveson missed an opportunity for framing a way of stopping crimes and misdemeanours which would be sustainable well into the future. Let me just briefly lay out for you what I think the missed chances were. Leveson, for example, says that the regulator should cover all significant news publishers, but he doesn't define what that means. He doesn't really seem to grasp what digital technology, and indeed many prior developments, are doing to journalism as a whole. He treats online, the internet, as a smaller, separate, and less powerful segment of publishing. At one point, in an extraordinary aside, he says that it is understandable, his word, that the gossip site Popbitch, which is online only, has lower reporting standards because it is so small. Popbitch has got 350,000 paid subscribers. By almost any standard, that's well on the way to being large. Let me give you some examples of the kind of points where I think digital change is going on, which impacts on what Leveson might have been thinking about. It can even be quite hard to determine what journalism is in the torrent of information. The biggest single change that's occurring at the moment is not the decline in newspaper circulations. It is simply the increase in the amount of information that is going round the world. Only a bit of it, of course, journalism. The wizards at Google say that between the beginning of human history and 2003, the world generated 2 exabytes of data. Don't worry exactly what an exabyte is. It's got 18 zeros. It's vast. Just 2 of them until 2003, okay? They now calculate that the world is generating that same quantity, 2 exabytes, every 2 or 3 days. Now, even if 30% of the internet content is porn and another 30% of it is spam, that still leaves you with a hell of a lot of information. And the problem of journalism is sometimes still the shortage of the right information, but it is now also the problem of the management of abundance. And what we call the story, the familiar vehicle, the unit of journalism, if you like, the standard unit, that's now something which is endlessly malleable. It can be revised and moved on and changed and split up and altered and corrected almost indefinitely if you wish to do so. We don't really know who the new publishers of the digital age are going to be. Are we going to have a large number of people producing information and a layer of aggregators and search engines who become the powerful publishers? We don't yet know. Privacy law is having a pretty hard time keeping up with technology, foreign servers, and everything else. I have read more than one article already by solemn media ethicists debating what the rules should be for sending pilotless drones to grab anybody's private information. What I am sure about is that anybody sending a pilotless drone with a camera over J.K. Rowling's garden will not consider themselves to be part of anything called the press. And there are people recommending that, and I think it's not a bad idea, that we should retire the phrase the press. Now, I can understand that Levison, who had terms of reference too wide for his own comfort, would think that there had to be limits to the futurology. But the problem is, preoccupied as he was with slaying the monster of popular paper strength, he has risked producing a backward-looking solution. I also think that there is a problem with his legal underpinning, because his report rather gives the game away when it says, well, if you can't make up proper statutory arrangements for a proper regulator and nobody can agree this, really the backstop for the regulator should be Ofcom. Now, there are obviously people who believe, and may want to argue to me in questions, that Ofcom, the big telecom and broadcast regulator, should take over the regulation of all journalism. It's theoretically possible. Ofcom, when asked to give evidence to Levison, said, "Not on your life. No, thank you." But Ofcom does have a politically appointed head. And when organisations like the International Press Institute, I declare my interest as a member of its board, or Index on Censorship are worried about these kinds of developments, I get worried too. Last reservation about Levison's prescriptions, the issues of who to include under a regulator, how to compel them to follow a regulator's sanctions or obey a regulator's sanctions, and funding it are going to be very big problems with or without statutory underpinning if regulation is front and centre when you look at the problem. Now, I want to just tell you quickly what I think would have worked better. The basis for accountability in journalism, in my view, is the law, and that's where you need to start. And I don't think you can balance privacy and freedom to report without a public interest test of some kind. I know that public interest tests, if there are any lawyers in the room, I can anticipate you telling me this in questions, that the public interest is very elusive and hard to pin down. When there was early in the development of privacy law, there was a case about the Mirror photographing the model Naomi Campbell. The case eventually went right the way up through the court system. 9 judges looked at it, and they broke 5-4 on the final decision. There was no obvious way to decide the public interest. But the fact that it is elusive and the fact that it has been abused does not, I think, render the public interest a hopeless test or one which we shouldn't be using. And if we were going to use a public interest test, this is not the moment to get into it in fine detail, But I think what it needs to do is to say that a disclosure must affect actually or potentially a collective entity or a community, that it needs to advance some benefit or harm, such as allowing a better decision to be made, a presumption in favour of disclosure, the free flow of information, a reluctance to limit communication, and a bias in favour of the quality of public debate or public reason. Quite a lot of versions of the public interest test then go into what you might call a shopping list about preventing people being misled, promoting accountability, exposing crime, fraud, or corruption. My point here is not to lay down my version carved in stone, but to say that this definition is where the argument should be. We already have a problem in British law with the inconsistency and weakness of these defences, and Levison was a wonderful opportunity, I believe, to have remedied this. Data protection, you have a public interest defence. There's an extremely good one written into the new libel bill, and I'll come back to the new libel bill in a moment. But there are none in the corruption, bribery, or official secrets laws, for example. And some very good and very important investigative journalism takes place right at the edge of the law. There is good new guidance from the Director of Public Prosecutions, but that falls well short of a defence built into the law. So I would say that it needs to be better defined, and I think the scope of public interest defence needs to be much better defined in privacy law. The judges have done their best with those two flat statements, remember, right to privacy, right to freedom of expression, but of course they have zigzagged over and across in an attempt to find the answer in their judgments. And what they have produced is a privacy law that is more or less illegible in newsrooms, and if you take legal action under it, it's a gamble. So, if I had a public interest test in these laws, and particularly in privacy laws, I would give the courts the ability to take the quality of editorial integrity, or if you prefer discipline, into account. I entirely agree with Levison that one way or another, cheaper and quicker access to remedy in law, particularly for libel and privacy, must be found. I'm in favour of the principle, but there are real technical problems about how this is being done. And some of Levison's solutions have clashed with one or two other things that were underway. For example, Lord Leicester, one of our greatest legal experts on this kind of law, thinks that Levison's recommendations on exemplary damages actually violates the country's undertakings in the European Convention on Human Rights. So my package of suggestions would give any news publisher, any platform, any size, an incentive to take part in regulation. Because if you were going to find yourself in court, you would need that defence. You would need a defence of your own editorial integrity. And that, I think, would produce a better, but still actually voluntary, regulator. It can produce an independent commentary on standards, investigate complaints, enforce transparency, the kinds of things which Levison has wanted to see in the new one, but in a slightly different framework. And if publishers didn't participate, they would be at risk and they would stand to lose heavily and often. Now just rerun in your mind quickly the history of the News of the World. That paper was often in court. My suggestion, a legal incentive, would give editors in the newsroom a strong incentive to control what happens, and I think that is the most effective way of doing it. And it integrates, what I'm trying to do here, is integrate law and regulation to the best effect. Above all, I would like to stay away from prior restraint and to concentrate regulation on editorial process rather than on content. So that, I think, would be the best way also of providing opportunities for the convergence of regulation if it has to happen in the end. So I come to my third question, what's to be done, given that Lord Levison didn't, inexplicably, take my advice. The story is, and I can't avoid this, an unfinished one. And a lot of the devil is in the detail. I think the government is right to be wary of legislating. They may have reached this view as a result of ordinary political pragmatism. They wish to avoid a split in the cabinet. But if so, I think they have reached the right careful conclusion, possibly for the wrong reason. Let me give you an example. There is a draft bill from the group hacked off, and it includes certain measures for control of the media, and I quote, the measures for control, for a legitimate purpose and necessary in a democratic society. When you've got ideas and drafts like that floating around, and you may say that a public interest defence that I was talking about is hard to pin down, but just try interpreting a phrase like, when media control is for a legitimate purpose and necessary in a democratic society. It makes defining public interest look really quite easy. I think we are looking to some extent in what has happened since Levison was published at the law of unintended consequences. Because Cameron said, I don't want statutory underpinning for whatever new system there is. However, if you're going to bring incentives into civil litigation, and that was what Levison wanted to do, he wanted to give incentives in damages for people to join the regulation system, legislation is almost certainly going to be required to bring that into effect. So what the government has tried to do is to start with a royal charter, which avoids legislation, but it's going to have to attach. I don't quite know what you do with the royal charter. Do you put them on top or do you hang them from it? Anyway, they will have to hang some legislation from it. And they've only just published the documents about this, but as I read the government's document, a royal charter can be tampered with by the Privy Council. In effect, that means the Cabinet can change it. That seems to me to be weaker as a defence than legislation might be. Have they got themselves here into a tangle? The Labour Party is apparently opposed to the idea of a royal charter, well, that's what they've said, but we don't yet know what their intentions are in detail. These are all very good examples of the delicate complexities and the devil being in the detail. The government proposal envisages two circles, those who are in the new regulator and those who are not. Publications in the inner circle, they're protected from exemplary damages, they have access to cheap arbitration, they may get costs even if they lose. You can qualify for the outer circle if you're anyone publishing news aimed at a UK audience. How are they going to enforce that for people with servers in the Caribbean when they aim it at a UK audience is just not clear. And this is not, please note, a theoretical question. Executives on the Daily Mail during the Leveson Inquiry talked more or less openly about moving the editorial operation to New York. I was chairing a lunchtime talk this week with a senior commentator from the FT. Now, he was just being playful, but he said, well, ultimately, if we don't like it, we've got a big operation in New York as well. So this isn't an entirely academic question. We now have rumours, there are only rumours so far, that the regional press dislike the regulations so much because of the likely very high costs they might meet that they're not going to go into it themselves. That would be truly bizarre. The Press Complaints Commission, much criticised, and quite rightly, worked for two often neglected categories of publication, the regional papers and magazines. As a regulation system, as a self-regulation system for them, the PCC worked really quite well. It would be very odd if we had regional papers outside any new system. Furthermore, from what little we've had from the government so far, it looks as if the representatives of the papers have watered down a certain amount of the stuff about the independence of the regulator. Levison said that in the new regulator, the chair and the board should be appointed, quote unquote, without any influence from the industry or the government. The current draft says without any direction from the industry or the government. Does that suppose a power of veto? We don't know. Levison said that the appointments panel will make appointments, or should make appointments. The draft charter says that the appointments panel will make nominations. Not quite the same thing. We will, in the future, have to tackle the plurality of ownership. Last year, Ofcom asked by the government to say, should there be upper limits on ownership for newspapers, thinking, no doubt, of News Corporation with 34% of the newspaper market. Actually, when Ofcom answered this question, they said better not have upper numerical limits, partly because they could see enormous problems with the gigantic reach, probably, of the BBC. So it's not completely surprising that Levison dodged this, but this issue will come back, and I suspect it will come back in the form of upper absolute limits, at least applying to the future. I cannot imagine a government making them retrospective. Here's something to take heart about. Transparency will advance anyway. The era in which journalism was something done behind a curtain and then the curtain was opened when publication happened, that really is over. There is now software to spot journalism, plagiarism, and it is far, far easier in the digital age to actually show what information lies behind things. I cannot for the life of me understand why the editor of the Financial Times does not insist, this is a paper moving rapidly to a probably all-digital future quite soon, why he does not insist on simply putting linked footnotes into what they write. It's incomprehensible to me. It seems to me that it would do them an enormous amount of good. The stuff from Levison on investigative journalism and the police is going to cause a lot of trouble. The Home Office have now put out for consultation regulations which are so stiff about contacts between newspaper reporters and police sources that it would almost certainly have prevented the reporting of the phone hacking scandal itself. Police sources were extremely important to that story, as The Guardian recently actually admitted in terms in an absolutely scathing editorial, pointing out, and this is equally, if not more important, that under the cover of the post-Leveson atmosphere, the Home Office are now threatening to strengthen the Police and Criminal Evidence Act, making it very much easier for the police to seize reporters' notebooks and materials. Likewise, Leveson's suggestion that investigative journalists should write contracts with their sources is well meant, but I'm afraid entirely impractical. This is an area, as I hope I'm giving you the impression, of messy chaos which favours people with agendas which might not be popular if everybody caught on to what they are doing. That is my lead-in to the manoeuvre the other day by Lord Putnam, David Putnam as he was. He pulled off an ambush in the House of Lords. The House of Lords was considering the libel bill, and he attached to it two clauses which are entirely to do with the regulation regime proposed by Levison. Putnam argued that this move was necessary to get the government to implement all of Levison as he would like. The libel bill is the culmination of, it's almost as long as a piece of string, this. It's the culmination of at least 3 years' work in Parliament, 15 years' work of discussion. It's on the brink of going through. It has been hammered into shape over years by every expert who could possibly be consulted to do it. Putnam's manoeuvre puts the entire libel bill at risk. And if the libel bill goes down, the cleverness of his ambush will, I hope, be forgotten, and the destruction of a valuable reform will be remembered as a piece of infamous foolishness which has lost, or would lose, a great deal more than it gained. Partly because the issues thrown up by Leveson's suggestion on arbitral process are very intricate. One example, given again by Lord Leicester yesterday, the godfather of the libel bill himself, a paper in the regulatory system which did not consult a regulator or went against advice would be liable for exemplary damages. Now that's Putnam's clause. That goes further than Leveson. And as Leicester pointed out, the only European states with a law like that are from inside the former Soviet Union. Into the bargain, he added, it breaches common law and the European Convention on Human Rights. So I can only hope that Labour and Liberal MPs will see that the best thing to do is to disentangle this link which could sink the libel bill. But let me not end on a pessimistic note. Overall journalism is going to get better, partly as a result of the catharsis that Leveson has brought about, and partly as a result of wider changes. But we are going to have to be very, very careful about the way we change law and regulation. Why am I optimistic? Who triggered the Leveson Inquiry in the first place? A journalist. Thank you for your attention.
Thank you very much, George, for disentangling this very, very complex web, which clearly is still being woven. We do have about 10 minutes for questions and comments, and Lauren will pass you a microphone. Who would like to begin? Yes, the lady there. Sorry, gentleman there.
Thank you. Actually, I got two. One is I didn't understand why the Princess Caroline definition of public interest is so crazy. As you summarised it, it sounded rather sensible to me. And the second is about the Ofcom view, if you're correct in saying that was why they didn't want to put the upper limit. I mean, should there not be a distinction between upper limit by a private corporation and control by an independent corporation with all the safeguards that have been put in place for the governance of the BBC?
Can I answer the second of those first? I mean, I think that that distinction is probably what they will end up with. I'm just rather struck that Ofcom still haven't come around to that point. They were asked by the government as independent advisors. They have no particular stake as far as I can see. And I just looked back at their last report, and I was just rather struck by the fact that they haven't got to that point. It may be that they think it would be subject to legal challenge, I don't know. But what you suggest is where I think things will end up. Princess Caroline, I think that would be if you're going to insist that, I mean, bear in mind the picture of her was taken on a public beach, right? It's not private property. If you're going to insist that pictures of people taken in public places can only be published if they're going to be the subject of some interesting discussion about their position, well, you're going to shut down a lot of information. That's why I think it's eccentric. Harmless information, among others.
Yeah.
Thank you very much. You said at the beginning that the heart of Levison is privacy versus free expression. I wonder if that actually is completely true, because there are two other things which he spent a lot of time on, perhaps one more than even one of those two, which was accountability and a lack of it, and a lot of the report seems to be about that. And the second thing is about truth-telling. So I'd be interested in your comments on whether you thought those two were important. But my question would be, what is your view about the degree to which it's important that third parties have rights on accuracy? This has been skirted around a little bit. I don't think there's been a conclusion, but it seems to me to be something that's very important. Not just groups, but actually being able to actually get at papers which aren't telling the truth. There's a hint that the new proposals from Black and Hunt actually say that we will accept complaints if they are about inaccuracy, but it's hazy.
Yes, well, haziness was the problem with a lot of the Hunt Black stuff. I mean, you're of course quite right that he also considered it at some length accountability and truth-telling. I wasn't suggesting that the only things that he were looking at was privacy and free expression, but I thought that the most difficult clash occurs at that point, because accountability are accountability questions which arise from that collision. Now, on the question of truth-telling and accuracy, I don't think that he had a very difficult question of principle, if you see what I mean. His issue was a more straightforward one there, which is how do you deal with it? There wasn't a rights clash involved. I was just indicating where I thought the difficult heart of the question was. But moving on, if I'm segueing from that into the second part of your question, I think it's absolutely fine and indeed very good for a regulator to be able to take third-party complaints. That's one part of the issue. The questions about accuracy, One of the things that goes on when you have an event like Levison is that a large number of people say, well, yes, I mean, it's not just that I'd like the media not to do what I don't like. What I'd like the media to do is to be what I'd like, which is an entirely different proposition. And one has to just note, pedantically, that different people have a lot of different versions of the truth. You can say that about some things, that's markedly and completely inaccurate, and we, the regulator, censure you for being inaccurate. But the idea that you can settle 100% of those questions never happen.
At the back, over the back there.
Yes, with the news that the European Union wants to have a firewall for websites opposed to it, would you say that that plus the Levison, that the political class can get away with murder now under the guise of this inquiry?
No, I certainly wouldn't. I didn't know that the European Union wanted a firewall against they have brought out a consultation document recently, which does talk about how it would be all wonderful if the media operated according to European values and so on, but it's not quite as bad as you... Well, I haven't seen the suggestion that you mentioned, let me put it that way. No, I don't think the political class can get away with anything, but, as I said, in this kind of atmosphere and with a very confusing moving target, it is well worth being vigilant about openness, the free circulation of information, as well as accountability and truth-telling. They're all important.
George, Harold Evans, in a recent lecture, perhaps based on his experience in America, suggested that one way of solving all this would be for an amendment which said Parliament shall pass no law which inhibits the freedom of the press. I wondered if you had a view on that.
I didn't mention this. I was at that lecture, and I didn't mention the subject of legislating in favour of press freedom because I think the discussion is artificial, if you see what I mean. We've already got on the statute book a pro-freedom of expression clause in the Human Rights Act. In fact, I was told the other day by Media Law, it's not even the only statute law with that kind of general statement. I mean, Harry is arguing from, it seemed to me, the power of the American Constitution, which is legally a completely different kind of foundation mechanism for the law. If you have something that says, you know, it would be a good idea if you did X in British law, what lawyers then spend a long time is they're just looking for other clauses in different laws which say, well, it would be a good idea if you did Y. You know, it's just, I don't think it helps.
Yes, here. And then, yes, one more after this, I think.
Very briefly, I do some work with the FT, and the reason that they don't have footnotes on all their articles is that it's too complex to develop a publishing system which does that for print and online. I think you'll find the Times has similar challenges, and you know, it's a very difficult thing to do well. It's not because they don't want to do it. But on your point, at the start you mentioned the chilling effect on the media, and you said you didn't have any evidence for that. I mean, it has been reported by many editors that, or a number of editors, that they now getting calls from people who are saying, you know, when Levison comes in, we're going to come after you, or you know what's going to happen. And I think that's reported by Steve Hewlett on the media show, BBC. It may not be the case. Are you really saying you think that the law or a potential law or potential regulation doesn't have a chilling effect, even if it doesn't come into being?
Well, I think some form of stiffer regulation is going to come into being, so I think it will change things to a degree, whether you would call that chilling. But I mean, you know, editors get people trying to threaten them with one thing or another morning, noon and night. It's their business to tell them to get stuffed. You know, it's what they do, it's what they get paid for. I mean, okay, one or two people may have been emboldened by the atmosphere, but I mean, do I think there's a serious chilling effect by what has occurred? No. If we get a bad regulation system, or if we get, you know, the ability to under, Putnam's idea, prior restraint on privacy case, that would be seriously bad. So things can go wrong, but I don't think they've gone wrong in a chilled sense so far.
And one last question down here.
George, thank you. That was admirably clear as well as splendidly erudite. We tend to think of this as a British issue, and we have a particularly acute British problem. But actually, the rest of the world, or much of the rest of the world, is facing similar issues, including the proliferation of suppliers of information and so on. Have you looked elsewhere outside Britain and seen solutions which are being generated which might be appropriate for Britain and which might be better than some of Leveson's ideas?
Leveson does a certain amount of this, although his discussion of it is very, very brief. He spent quite a lot of time looking at the Irish system. I don't really have the time to explain, the differences are a bit complex, but eventually rejecting that kind of system as not likely to work. Most of the systems don't have the kind of muscle power that he thought he needed. That's the really short order. He thought this has been so badly abused, the system of self-regulation has been so corrupted, this has got to be a very powerful revision. So he didn't really find parallels elsewhere that were very useful to him. But I will say one thing about the international scene. One of the fascinating things about the changes that's going on is that all the changes in America are in a kind of tabloid direction. What's broken out in the internet is popular journalism. It's extraordinary. And they are going to find themselves in the midst of these issues quite soon. They won't be it won't be identical, won't be the same, won't take the same form, but I bet you that in the next 10, 15 years in the States, it's going to be a big debate about privacy and disclosure and that kind of thing, which they haven't really had before.
Well, I think we must stop. That's one of Gresham's rules. Stop at 7 o'clock. So may I once again thank George for a really interesting and, as just been said, erudite lecture. Thank you very much, George.